an absolute pleasure for me to welcome you in this beautiful venue of Parking Hotel. Today is the final round. Yesterday, for those who were here, we had a couple of rounds of preliminaries, and we selected, the panel of judges selected two of the best teams that will be today in the final.
Good morning, everyone. I'm Justice Wiwabada Charity, and I will be the presiding justice for this hearing. I'm with Justice Maggie Bayingana on my immediate left. Next to her is Justice Nyirurugo Jean-Marie. And on my immediate right is Justice Umurungi Providence. On my far right is Justice Karist Dahayo. Today, the 15th of October, 2021, we have a case of prosecutor versus Major General Dragon, who is accused of committing crimes against humanity and war crimes that were committed in the year 2013. The court wishes to submit that all parties are represented in this case. And I take this moment for the prosecution to introduce their team before this International Criminal Court in the pretrial chamber seated in Kigali. It's now time for the prosecution to present their case before this court.
My lords, we are going to be assisting the court in showing how the intervention of Alabaster's military on the territory of Wanu without the latter's consent and the existence of an armed conflict between the former and the LLA forms a clear indication that the conflict at hand was an international armed conflict, but along with a parallel non-international armed conflict. We are further going to assist the court in directing you to the fact that the war crimes of ordering indiscriminate attacks that the accused assembled before you knew would occur under the ordinary course of events, but nevertheless went ahead and never considered any of the principles under international humanitarian law and went ahead and ordered the attacks. Under the admissibility, we are going to be addressing two main components. To begin with, the principle of complementarity. Pursuant to Article 17 of the ICC Rome Statute, it requires that the ICC's jurisdiction only comes into play when the concerned states are either unwilling or unable to genuinely prosecute or investigate the crimes. In assessing unwillingness, the same provision, Article 17, adds that unjustified delay, inconsistent with the intent to bring the alleged crimes to justice, amounts to unwillingness. My lords, the inaction of the concerned states since the year 2013 to date, we pray and submit that it should be accorded the value of unwillingness from the concerned states, thus welcoming the court's jurisdiction. Allow me proceed by addressing the issue of the gravity threshold, under which the prosecution wishes to invoke the case of Lubanga, paragraph 234, which articulated some questions that need to be answered for the gravity threshold to be met. The first question that was addressed by the land justices in the trial was the question of whether the crimes were committed as a widespread. Honorable Justices, allow me invite you to the facts of the case. The crime of starvation, firstly, was committed on a total of 120,000 civilians in the city of Vendaski. 120,000 civilians, my lords. Further still, he denied humanitarian aid from entering the city of Vendaski, subjecting starvation and deprivation of objects indispensable to their survival on a population of over 30,000 civilians. 30,000 civilians. The accused went ahead, as if that wasn't enough. He gave an order to level down the shopping center. A shopping center that wasn't used as a military objective. Further still, as the commander, as I earlier depicted, he had subordinates under his control. His subordinates went ahead and attacked civilians in the hospitals and schools. He never did anything, no? He never managed to prevent them. Neither did he even try to punish after. He didn't. He didn't. Further still, and which is very important, the accused was there and the subordinates attacked the cathedral, which has special protection under international humanitarian law. He did nothing. The prosecution submits before you, Honorable Justices, that the conflict at hand is an international armed conflict, but with a parallel non-international armed conflict. In addressing the former, which is the international armed conflict nature, ICRC notes that any unconsented to military operations in the state of another, my lords, to proceed on the latter, which is the non-international armed conflict character of the conflict, both ICRC and RULAC meet on one single point, that the existence of an international armed conflict does not eliminate the existence of a parallel non-international armed conflict between the attacking state and the armed group on the same territory. However, to qualify an armed conflict to be a non-international armed conflict, the land justices, in their wisdom, in the case of Haradinaj, paragraph 44, they pointed out criteria that has to be met. The first criteria was about the identity of parties. Allow me proceed to the third issue, which was addressed by the land justices, which is the issue of sufficient organization. On that issue, my lords, allow me to invite you to the case of Lubanga, paragraph 324, where it was depicted that for an organized armed group to be considered to be sufficiently organized, it should be having the ability to mount military operations for a prolonged period of time. We therefore submit that this case at hand meets that nexus that is required by law. Please, as you, my lords, allow me proceed now to the modes of liability. Your honors, the modes of liability, firstly, we are charging Major General Dragon for the order to attack, for the order to attack the civilians and their objects. In that matter, allow me invite you to the case of Mudachumura, paragraph 63 of 2012. It was noted that for someone to be held liable, that person must have used his authority to influence others to commit a crime which in fact occurs or is attempted. Inviting you, your honors, to the facts of the case, the accused before you ordered an indiscriminate attack using indiscriminate weapons on a civilian city, and this in fact occurred. And at the same time, it was attempted. It occurred in the context that we have evidence of people who were injured in the hospitals, pursuant to the facts of the case. It was attempted pursuant to the fact that the city was bombed for over 4 good days, uninterrupted bombing of the civilian city. My lords, these are not just our words. We want you to experience. I know it may not be good to your eyes to see, but we need to, for matters of clarification, we need to help and assist this court to understand the gravity of what we are talking about. These are the weapons that were used on a civilian city, my lords. These are the weapons. These are cluster munitions. They are totally indiscriminate. They are actually prohibited explicitly. They are prohibited. These ones, when they are dropped in an area, they drop off submunitions, which are not directed because it depends on how it has been dropped. It will throw off submunitions, which cannot be controlled. As a matter of emphasis, they accused his country of origin and the territory on which these attacks were committed. They are all parties to the convention prohibiting the use of cluster munitions. My lords, allow me proceed to prove the mens rea in this particular case. The mens rea.
And so you have 10 minutes remaining.
Okay. Thank you, my lords. Pursuant to the mens rea, the accused had the intention, pursuant to Article 30, he ordered an indiscriminate attack upon which he ought to have known, under ordinary circumstances, that by ordering an indiscriminate attack on a civilian city, he knew that civilians and civilian objects would be the likely victims in the attack. Upon that, my lords, allow us to submit that you find him guilty of the order to attack the civilians and civilian objects. On that juncture, my lord, allow me invite my co-counsel to proceed with the modes of liability. Thank you very much.
Your Honors, may it please the court, I would like to proceed to the second count, which states that the accused should be tried and found liable for the use of starvation as a method of warfare provided under Article 8(2)(b), Roman numeral 25, and Article 25(3)(a). Your Honors, pursuant to Article 30 of the Rome Statute, it provides that for one to be held liable under Article 25, he must have prompted another person to commit the crimes which in fact occurs or is attempted. To prove the mens rea, the accused knew by putting a city under siege of a city containing the civilian, it was obvious in the ordinary course of events that this civilian population would lack food, water, and medical supply. Hence, we submit to this honorable court that the accused should be held liable under Article 25(3)(a) for the commission of a crime of starvation as a means of warfare. My lords, proceeding to the second count, the accused should be tried and found liable for ordering an attack on the cathedral punishable under Article 8(2)(b), Roman numeral 9, and Article 25(3)(b) and Article 28 for the omission. My lords, to prove, first it should be noted that the attacks directed against cultural objects are prohibited except in cases of imperative military necessity, pursuant to Article 4(6) of the 1954 Hague Convention and of protection of cultural property and its 1999 second protocol, respectively. My lords, proceeding to prove on Article 28, proving the omission of Major General Dragon, the accused assembled before you, the accused failed to prevent and punish the acts of his subordinates who attacked the cathedral. Proceeding to the crimes against humanity, my lords, the accused should be tried and found liable for the crime of murder and other serious injuries punishable under Article 7(a) and (k) and 25 and 28. To prove the accused laws, Major General Dragon ordered indiscriminate attack on the whole city of Vendaska, my lords, on the whole city, composed of 30,000 civilians, which lasted for 4 good days, hence resulting in 2 civilian injuries, pursuant to the facts of the case in paragraph 10, where it is stated that hospitals were housing or were sheltering the injured people. Hence, he should be tried and found liable under Article 28 for omitting to punish or prevent the subordinates. We proceed to the prayers. May it please the court. The prosecution respectfully requests this honorable court to confirm the charges under the Rome Statute for the following reason. Firstly, that the ICC has jurisdiction over the case. And
Counsel for prosecution, the bench here present has a few questions that require some clarity regarding the factual issues, the evidence advanced, and the legal issues that you raised. I'll start with Justice Maggie, or to ask the question to the...
Thank you, counsels. I would like to bring your attention to a submission you made, saying that you believe that this is an international armed conflict at the same time, or happening at the same time, a non-international armed conflict. What does international humanitarian law talk about or provide for laying of siege? I would like to hear your submissions about what you think the law says about laying of siege, because according to the facts of the case, there was a siege on the city for over 45 days, and I would like you to inform this court what you believe international humanitarian law talks about laying of siege. Thank you.
My question to the prosecution is the protection of civilians and cultural objects absolute? If yes, how and why? If no, to what extent? Can it be protected or not protected?
The prosecution, how do you say that General Dragon had intention to kill civilian while, for example, the schools, hospitals, cathedral were used as military objectives?
It's now your turn to respond to the raised questions.
To begin with, what IHL says on the issue of siege. The prosecution advances that siege is allowed. Siege is allowed in an armed conflict. But that siege must be intended to make the opponent surrender. However, it is not absolute. When you lay siege on a civilian city, you are obliged to allow civilians or not anyone who is not a militant, right? You allow them to leave or vacate the place. Additionally, when you lay siege, you are obliged not to unreasonably withhold consent to allow humanitarian aid to be advanced to the civilians that may be staying in the city. Let me invite my co-counsel to proceed.
You need to provide the legal basis for your arguments.
Honorable Justices, this is state practice. We base on state practice to invoke the justification that we provided for siege, how siege can be used in wartime.
in the customary rules, with regards to customary rules, there should be respect of proportionality principle, principle of distinction, and precautionary measures. When Major General Dragon, drawing your attention to the facts of a case, in the paragraph 8 of the facts of the case, he ordered indiscriminate attack and use of indiscriminate weapons, which injured civilians' lives and destroyed.
My lords, just to supplement her, it is a state practice. It is international customary law that civilian properties and civilians themselves cannot lose protection. They should not be objects of direct attacks. They, however, only lose such protection only and for such times, I repeat and emphasize, only and for such times when they are used as military objectives. To be used as a military objective, it requires that the person using it is gaining a military advantage. It should not be just occupying. No, you should be gaining a military advantage from that use. So just occupation, like my co-counsel was advancing, like of the cathedral, LLA being in the cathedral, wouldn't justify attacking a cathedral at any ground. My co-counsel wants to...
As a follow-up on the response, given the fact that the onus of proof is on the prosecution or the burden of proof, we expect the prosecution to provide proof beyond reasonable doubt that Major General Dragon committed the alleged crimes as you're advancing. How would you legally assess the LLA's use of hospitals and schools during hostilities, or in line with the provisions of international humanitarian law?
They were just occupying it, and the submissions of my land friends from the defense justify that as well. It is also important to note that the existence of civilians, but mixed with maybe combatants, does not remove the civilian character from civilians. The existence of the LLA also in the civilian objects does not necessarily remove the protection from the civilian objects. When the LLA being in the schools and they are also civilians, and also the fact that the hospitals and schools are civilian objects, they ought to have taken into consideration in case they find it like it has turned, it meets the proportional principle, like she stated. They have to further ahead respect the principle of distinction. That is the only aim and target at the LLA members. But pursuant to the facts of the case, they just responded, killing both civilians and LLA, also resulting from their attack, Major General Dragon's attack, the damage to electricity. Thank you, my lords.
It's now time to hear from the defense of Major General Dragon, and you have 30 minutes allocated, after which the bench shall interject questions in case of any matters that need further clarification. The floor is yours.
Thank you. President of the court, members of the court, if it pleases the court, allow me to proceed with a brief account of what really transpired in Operation Anchor of Stability. Your Honors, in the wake of LLA's terrorist activities in the Kuru province on the border of Alabasta, and LLA positioning itself as an imminent threat to the peace and security of the Alabastan people, the Alabastan government took necessary measures and launched an Operation Anchor of Stability to put an end to it all. Your Honors, in line with the general principle of actori incumbit probatio, the prosecution has produced insufficient evidence to establish claims pertinent to holding Major General Dragon accountable for alleged war crimes and crimes against humanity perpetrated in Kuru. Your Honors, the defense for Major General Dragon hereby denies the existence of an international armed conflict as claimed by the prosecution. Your Honors, the defense hereby submits that due to the prosecution's failure to establish sufficient and credible evidence and fulfilling elements to establish the responsibility of the accused and the failure to establish circumstances under which such crimes occurred, Your Honors, the trial chamber should acquit Major General Dragon for the war crime of... Your Honors, this means, for example, that the armed group should be under a certain command structure and the capacity and have the capacity to sustain military operations. Your Honors, evidence from the facts of the case, paragraph 2, Your Honors, the liberation for the Legions for the Liberation of Alabasta was an organized armed group under the command of Commander Sabo. And moreover, they had turned the Kuru province into a military base for their training and manufacture of weapons. And your honors, evidenced by paragraph 4, they were able to take on Alabastan armed forces when they marched into the province of Kuru. Your honors, the intensity of the conflict, the intensity of the hostilities is also fulfilled. Your honors, Article 3, common to the 4 Geneva Conventions, still stipulates that the hostilities must reach a minimum level of intensity. Your honors, this may be the case when the hostilities are of a collective character. Defense contends that these standards have not been met whatsoever for any of the charges against Major General Dragon and requests this court.
The undecisiveness of what took place in Kuru, either if it was an international armed conflict and a non-international armed conflict, should not go unchecked under strict legal scrutiny. Your honors, with that being said, I would like to invite you to go to the page 5 in the submissions of the prosecution. Your honors, on the issue of whether what was taking place in Kuru, I would like to invite you to go in the footnote 9. In the issue of what was taking place in Kuru was an international armed conflict or a non-international armed conflict, I'm not going to go outside the commentary they used. I'm going to use that same commentary because it intrigued our intellect as the defense, and we went and read through the commentary. But there are some interesting facts they left out just to ease their case and submit it before this honorable court. And that's what I'm going to bring to your attention. So the pursuant, it also follows and says, pursuant to international humanitarian law, every situation has to be classified as international or non-international armed conflict, page 472, ICRC opinion paper. The prosecution cannot have it both ways. They want to prosecute Major General Dragon with anything and everything. Be it international armed conflict elements, they go in that line. A crime they see fit in a non-international armed conflict, that suits them too, because it's a runaway prosecution. This is a runaway prosecution. Your honors, the retreat of LLA's force in the St. Augustine's Cathedral, by fortifying it, by legal definition, it means it was defended. It was defended, it was fortified, and they were planning to launch attacks on Alabasta. They said that Alabasta should have warned them. This was not a friendly football match. You don't warn your enemy, oh, I'm attacking you tonight, be ready, I'm coming. You don't do that, your honors. The only warning they gave was to tell them to try to initiate the negotiations and see if they could evacuate. But I'm inviting you to read facts paragraph 12, the unwillingness. This was Commander Sabo and his die-hard members of LLA. It was, you take us in a coffin. They're not leaving the cathedral, your honors. So them claiming that he should have warned them, yet this was a military objective, it doesn't stand any ground, and it's unfounded. By that, after the attack, it was declared that peace has returned in Kuru. After 8 years, I thank them for clarifying this. This was LLA had on chokehold, had occupied this place for 8 good years. This was a conquest and the return of peace. So them painting Major General Dragon as a bad person in this story, your honors, as he is sitting here with us today, he is not. And that's what the defense will keep on proving to this honorable court. Your honors, in Bajiri Shema trial chamber, paragraph 39, although superior status is required for a command responsibility to be imposed, the presence of such position cannot be determined only on the basis of the formal status. 5 elements must be fulfilled. The suspect must be a military commander or acting in the capacity which the defense hereby acknowledges. B, the suspect must have effective command and control and effective authority and control over the forces of the perpetrated crime. I'm going to stop here. Your honors, Major General Dragon had no effective control. If you allow me to read for you, I'm like to invite the bench.
Minutes remaining.
Thank you, Your Honors. Major General Dragon ordered his armed forces to show that he had no military effective control. He ordered the armed forces not to attack. These are the facts, Your Honors. Not to attack. Yet they went away out of their way and attacked the St. Augustine's Cathedral anyways. So that's where we hear Major General Dragon talking. His last saying before the attack was not to attack. Later on, we are told that due to its strategic location, the St. Augustine Cathedral was attacked. But we are quoting our client, the last words he said was not to attack. And this, hear me, right, just proves that he had no effective control at the time of the commission of the crimes. So, Your Honors, allow me to invite Denise Isimbi to continue with the other counts.
As to the Counsel for Defense, we will not be making any submission in defense of attacking civilian population, as the prosecution was not specific on what they are charging Major General Dragon. Your Honors, the prosecution backed their charge with Article 8(2).
Furthermore, this means that Major General Dragon cannot be held criminally liable of the aforementioned crime. It is outside of this court's jurisdiction in situations of non-international armed conflict. Your Honors, thank you for your attention. I would like to go back to my prayers for relief. Your Honors, we appreciate indeed what you have heard from the prosecution. It's horrible when the way they painted Major General Dragon. But your decision should go as far as facts are concerned. Your Honors, the prosecution, the defense hereby rest their case, and we hope the charges are dismissed. Yeah, thank you.
Thank you, Honor. I had actually the same question. If you agree that it's only the non-international armed conflict, while the prosecution says also there is aspect of international conflict, so how would the different classification of this conflict on the territory of WANU affect the applicable rules of HR? You have raised, even on your last comment, regarding the starvation crime. So I want to ask you, because according to the facts brought before us, Major General Dragon refused to allow humanitarian aid in Verdansk. So was he correct if he did that? If not, then why?
Justice Karist also has a question.
My questions are, one is about what does the IHL provide about the use of cluster munitions, and how are they regulated under the existing convention against cluster munitions? And in relation to that, explain how justifiable it is for Major Dragon to have ordered his troops or his armed forces to attack using cluster munitions. Also, making a follow-up question on what the presiding judge just mentioned, in relation to Common Article 2 of the 4 Geneva Conventions, explain how the occupation of a territory, even if there is no conflict, would not materialize to be called an international armed conflict.
On the issue of IHL and refusing humanitarian aid, as my co-counsel Denise Isimbi said, that it's not unlawful. Your Honors, Major General Dragon, we have to remember this, in the Kuru province, has been infiltrated by LLA for 8 good years, as they said it, and they put it for this honorable court. So Major General Dragon could not tell a combatant from a civilian the moment he entered the Vendaska city, and he was welcomed by heavy fire. Your Honors, but however, there's one thing that Major General Dragon did and proves that he applied the principle of distinction. Your Honors, after the International Humanitarian Organization has put forward the numbers of people identified as civilians, Major General Dragon allowed a number of them to evacuate. That number is a big number, Your Honors. 90,000 civilians were allowed to evacuate. Thank you, Your Honors. I would like to pass the mic over to Denise Isimbi to continue.
Your Honors, clarifying on the civilians' participation in the hostilities, Your Honors, in facts of the case, paragraph 8, I quote, the LLA called on all civilians to move to the center of the city to take shelter in schools and hospitals. Members of the LLA fortified schools, churches, museums, and hospitals. Why were they fortified, Your Honors? And why did the civilians go ahead and follow the rules they were given by LLA to go to schools and hospitals? And moreover, paragraph 9 indicates that after that, LLA started launching attacks from schools and hospitals that were sheltering the civilians they told to come and occupy. This is a clear indication that they were already taking direct part in hostilities and had lost their protection as civilians. Your Honors, furthermore, on cluster munitions, the question raised by Judge Calixt, IHL prohibits the use of cluster munitions.
Your Honors, also according to the Hanovic case, especially in Appeals Chamber paragraph 4, the laws and the rights of war not only applies to the armed forces, it also applies to the militia as long as they fulfill one rule of being commanded. Your Honors, Major General Dragon was a commander and they fulfilled these rules, so they should not be held
There is a
accountable.
follow-up question on the issue you've raised.
Thank you. We are happy to receive the question. You raised a question which goes to Section C of the Cluster Munition Convention, especially in the C paragraph, where they say it's also a crime to stockpile or even possess the cluster munitions. Your Honors, you are right on that point, and you are right, that's true. But we have told you, and you have demonstrated, many cases where Major General Dragon, as a commander, had no effective control. So this leaves a room for doubt. And this, we are directing the prosecution to go in the other way of finding who ordered the use of cluster munitions. Because we have proven to this honorable court that there are times where Major General Dragon was unable to have effective control and the superior authority to his army. So this leaves a room to think that maybe we're just putting it that it's not a fact, but it could also be a fact, Your Honors, because we have proven to this honorable court that at times Major General Dragon had no effective control. Why not this time around?
Upon hearing submissions of both parties, the prosecution submissions and the defense submissions, both parties shall have 20 minutes for rebuttal and presentation of their closing briefs.
Present our rebuttals as the land councils from the defense has alleged. To start with what the defense has raised about crimes against humanity with regards to the widespread, Your Honors, in the case of Prosecutor versus Katanga, pursuant to paragraph 394, the case of 2008, they stated that the term widespread relates to a large-scale nature of attack and number of targeted persons. Your Honors, the targeted persons in this case we have at hand was 30,000 civilian population. Talking about the large-scale nature, the attacks were directed against the whole city of Vendaska. My lords, the whole city of Vendaska, ordering to attack what was left of the cathedral. Meaning that in the first attack, where Major General Dragon ordered indiscriminate attack and the use of indiscriminate weapons, these weapons severely damaged the cathedral. And this makes Major General Dragon held liable under Article 25. Another thing, he was held under Article 8. they talked about effective control. Major General Dragon had effective control given the fact that the subordinates respected his order and bombed the cathedral after 3 days for what they so-called military necessity, as my co-counsel will prove about the military necessity, how it did not occur.
Allow me refer you to some of the statements that have been advanced in their allegations. Firstly, they claim that they would use any weapons available in response. My lords, we are here for humanity. The issue here is humanity. And it should be noted before this honorable tribal court that under international law, the principle of reciprocity does not apply. They are claiming that the fact that LLA used weapons, they also had reasons to respond with probably similar energy or even more grave weapons. My lords, that is what they are advancing before you. They are actually trying to mislead the court. These are the people they are qualifying, actually from the horse's mouth, the client they are trying to defend. He stated himself that the people that remained in the city, they are supporters and terrorists. Mere remaining does not make them directly participate in hostilities. It is thus our humble submission that in their response to this allegation, to our submission, they should prove to us how these civilians were directly participating in two hostilities, and they should also show us the test that is needed for someone to directly participate in hostilities. The 5 days, as a matter of fact, inviting you to the facts of the case, my lords, the 5 days weren't enough. According to the facts, allow me to invoke the semantic of language, they said the civilians, the 90,000 they are claiming that left, they left after, not within. They left after the 5 days, pursuant to the facts of the case. They never left within. So the 5 days that were given were just trying to legitimize their attack on the people that may not be able to live within the 5 days. Therefore, they launched the indiscriminate attacks, well knowing that the 30,000 were still in the city. They knew that. He also acknowledged that only that he tried to disguise in the fact of calling them supporters without any proof. My lords, there was an alternative. There was an alternative. And that alternative was attacking the military arsenal. It would avail to them the same, actually similar, if not even better, military advantage. How? Instead of bombing down the cathedral, they would have bombed the military arsenal, and by so doing, these people, they are claiming that they refused to evacuate the cathedral, would come out because they were getting weapons from the military arsenal. Without the military arsenal, what would they use? It is my humble submission that their allegations should not be taken into consideration. And the fact that we have proved that the material and mental elements pursuant to Article 30 of the ICC Rome Statute was proved, they failed to respond to our charges. And yet, after us proving the burden shifts on them, it is our humble submission to you that they just admitted to the guilt of their client indirectly. But that lies in your hands, honorable justices.
Thank you, my lords. May it please the court, I would like also to talk about what they done different from the prosecution. In fact, on the starvation, that starvation of civilians is allowed under IHL. Yes, we can't contest this. It's allowed, but with limitation. It's allowed when it's targeting the military combatants, when it is just to weaken. In this case, it should have been used to weaken LLA, but even though they claimed that the civilian had evacuated, we have the 30,000 civilians that remained in the city of Vendask. And they were not the only target. The LLA here wasn't the only target, but civilians also were in their need of medical supply, food, water, of which they denied. Major General Dragon declared that no humanitarian aid would be allowed in the city. He was, in the ordinary course of events, attacking or directing or targeting the 30,000 civilians that had remained in the city of Vendaska. So we submit that this should also be taken under consideration, my lords. Thank you.
Shortly, my lords, if you kindly permit me, I also wish to emphasize on that issue. They alleged that we are claiming starvation that starvation is only punishable under the ICC statute in the international armed context. My lords, I don't know if they have forgotten the nature of our conflict at hand. We are prosecuting their client based on, in the context of both a non-international and an international armed conflict. But the crime of starvation was committed in the context of an international armed conflict. This juncture, my lords, allow us to rest our case. Thank you.
We can now hear from the defense team of Major General Dragon.
Your Honors, there was no policy, Your Honors, of committing this crime against humanity. Your Honors, they also said the authority coming before you with the law and order. Your Honors, they should also be the authority that tells the truth. The way they're explaining indiscriminate attack, Your Honors, according to the facts, paragraph 9, they're saying we used indiscriminate attacks. According to customary international law, the rule 12 stipulates that indiscriminate attacks are those methods and means which cannot be directed at a specific military purpose. In this case, Your Honor, the present case, our Basta armed forces launched attacks on hospitals and schools, which also we hereby submit that it was done within legal bounds since this was a military purpose. They also did that without committing a crime of indiscriminate attack because this attack they went on a specified schools and hospitals. So indiscriminate attack means methods which cannot be directed. In the case at hand, they're saying that this St. Augustine Cathedral was fortified. By legal definition, fortifying means defending. This was a military objective. So they want to leave a strategically located military objective just to attack another. That's not Major General Dragon. This was a conflict between our Basta armed forces and the LLA. And in the cathedral, there were top members of LLA and their commander, Sabo. And how the case at hand ends and how the peace returns in Kuru is when this cathedral was destroyed.
The prosecution kept on invoking the principle of imperative military necessity. Your Honors, the LLA occupying the St. Augustine Cathedral as a cultural property is a clear indication that they wanted, in fact, they had acquired themselves a new military advantage by occupying a protected object. Your Honors, by occupying a protected object, they had a clear military advantage over the Alabastan armed forces, which cannot be ignored. Therefore, the prosecution cannot come demanding Major General Dragon to ignore, the Alabastan armed forces to ignore the fact that LLA forces had turned the St. Augustine's Cathedral into a stronghold. It is reported in the facts of the case that paragraph 11 that it was the last stronghold of the LLA.
Also, Your Honors, the defense humbly requests the dismissal of the charges under the Rome Statute, all charges as you have heard them and the prosecution has submitted them to you. That's the only thing we will say, Your Honors. We rest our case.
Having heard the submissions of both the prosecution and defense regarding the case of Major General Dragon, who is here present in the pretrial chamber of the International Criminal Court, seated in Kigali, for charges of crimes against humanity and war crimes that were committed in the year 2013 or in the territory of Wanu, Vandaska City in Kuru province. The court or the chamber hereby resolves the hearing for deliberation, and the pronouncement of the decision will be delivered on the 15th October 2021 at 1 p.m.
Oh, that was the main activity of the day, the final round of our Moot court. And you followed the arguments from the prosecution and the argument of the defense. What I could say is that may the winning or may the best team win.
Good afternoon. Yeah, we would like to appreciate all the participants for the visible hard work they put in the preparation of this National Moot Court 5th edition. We also wish to appreciate their lecturers for the training and coaching accorded to the students that represented all the various universities that participated in this moot court. As it is with every competition, there must be a winner, but that doesn't mean that the other teams or the others are losers, because every competition has to go with the winner. From the comments of the bench, all teams have worked hard, and there is a great improvement if you compare with the previous moot court competitions. And that calls us to say congratulations to all the teams that participated. And also congratulations to the 2 teams that managed to participate in the final competition. Before we announce the final results, we would like to provide comments and pieces of advice to the mooters, because it's the beginning of the journey still continues. And with that, I would like to invite Justice Bayingana to give general and specific comments on behalf of the whole bench.
Thank you so much, all participants and all teams. From our side, we are very excited that such brilliant people are joining our profession, and I would like to provide a few comments from what we've observed. Some of the comments we gave them yesterday, but it doesn't hurt just to emphasize some of them. I will start by reminding you again about the importance of body language and posture. Yesterday we had talked about the importance of not stooping down or having a very, confused or unsure posture. Just stand, be confident, and convince the court with your ideas and with your body. Okay, that's number 1. Number 2, we want to see clarity of your ideas and arguments, especially as it relates to the law. State the law clearly. We have noted that sometimes you will simply cite an article and say, according to Article 28, and then you move on. 28 of what? You have to be very specific, because there are different laws, there are different statutes that you're referring to, so you have to be very clear. Don't just say Article 1 or Protocol 1, or make sure that you do a proper citation. You need to be convinced of your own ideas and of your own position. If you're not convinced, you're not going to convince anyone. We need to see a sincerity. You actually believe in what you're saying, so that you're able to convince the court. It is always a good idea to present to the court and say, I'm going to speak about this and this and this, and my colleague, co-counsel, will speak about this and this and this, so that the court is already aware of what you're going to cover in your submission. We noted today, especially, I'll give comments, for example, for the prosecution. Don't waste so much time talking about jurisdiction and legal principles. Unless somebody has challenged that, then in your rebuttal you can spend a lot of time on them. Focus on the charges and focus on presenting the evidence to prove those charges. Make sure the charges are clear, make sure the laws that you're referring to are clear, and the evidence that you present to the court is very clear and convincing. Now, for the defense, your job is to cast doubt on what they have established so that you are showing the court that they haven't proved their case beyond a reasonable doubt. You need to show weakness in the prosecution case without attacking their person. That is the other thing we have to remember as lawyers. We have to respect each other. We have to use professionalism. You can disagree with the ideas, but you cannot attack a person. Move from one idea to another. Don't have different papers flying. You're picking down, you're picking them. Then you have an idea, but you've forgotten where you've written it, and you're looking, you're fidgeting. So just be calm, organize your things well. Write, even if it's two ideas on one page, and then move to another. Have one folder, staple them if it needs be, so that you don't have papers flying and you don't look well put together. I think those are our comments, and I wish you good luck. Thank you.
Thank you for presenting the comments on behalf of the team. Following those comments, we would like to announce the outcome of this 5th edition International Humanitarian Law National Moot Competition. And we will start with the best written memorials, both for the prosecution and the defense. The best prosecution memorial was done by the University of Ines. You can give a round of applause. And the best defense memorial was from ELK. Secondly, we would also like to announce the best speakers as per the participating universities. The best speaker from the University of Rwanda was Derek Buziga. And the best speaker from the University of Kigali was Frank M.S. Samuel. The best speaker from the University of Ines was Umuhoza FG. Umuhuza, sorry, it's Umuhuza. Umuhuza Faraji. And the best speaker from ELK was Ngoga Samuel. Now we go to the overall best speaker among the different best speakers. That was Derek Buziga from the University of Rwanda. Congratulations. Next, from the panel of judges in our analysis, we want also to bring to the attention of the audience the winning teams. I'm sure everyone is waiting for that. I'll start with the run-up team. The run-up team is the team from the University of Rwanda, which was the prosecution team. Congratulations to the team. And the winning team was the defendant team, which is from the University of ELK. Congratulations. With that, I would like to call upon the organizers for the awards.
We have to congratulate the panel of judges. As you may see, these are the finest. These are the finest legal minds in the city. For the awards, we'd like to request the guest of honor, to request also Ambassador Kavaruganda Guillaume, to request also the head of department to help us in giving the awards. Okay, we'd like to request the winning team to come forward and receive their awards. We would like also to request the run-up team to come forward and receive the award. We would like also to have the best memorial defense to come forward and receive the award. Congratulations. Now it's the time for the best memorial prosecution. Ines Ruhengeri. Then let's go to the 4 best speakers in all the participating teams. We'd like to have the best speaker for University of Rwanda. The best speaker for Ines Ruhengeri. The best speaker for University of Kigali, sorry. The best speaker for ULK. Now it's time for the overall best speaker of the competition. Eric Buzigi. Congratulations. Thank you very much for the panel again. Now it's time for concluding remarks, but we'd like to have the head of delegation to come and present or introduce the guest of honor. Thank you very much.
Justice Dr. Aimé Muyuboke Karimunda, representative of Honorable Chief Justice of Rwanda, Ambassador Guillaume Kavarunga, representative of Honorable Minister of Foreign Affairs and International Cooperation, Dr. Wibara Charity, representative of Prosecutor General of Rwanda, Bâtonnier Julien Kavaruganda, President of Rwanda Bar Association, representative of public and private institutions, deans of law faculties, Mr. Emmanuel Mazimpaka, representative of the Rwanda Red Cross, member of the panel, our judges today, ICIC colleague, distinguished guests. I have the pleasure to conclude this session of the 2019 Moot competition and thank you all for your participation. I would like to thank in particular the 5 schools of law, which worked intensively to build competitive team for this event. The team demonstrated deep knowledge and a passion for IHL, as well as strong skill in advocacy. It is our hope that this competition will help to create vocation among the candidates in order to shape the next generation of leaders in Rwanda. The main objective of this competition is to increase awareness and interest in IHL, to promote academic excellence in the student community, to develop advocacy skill, as well as to enhance students' knowledge of the ICRC and Rwandan Red Cross Society in their role to promote IHL in the world. IHL is indeed at the heart of our mandate and mission. Since its creation, the ICRC played a key role for the adoption for the first Geneva Convention that was regulating the conduct of hostilities and warfare. The ICRC was then given the responsibility to be the promoter and the guardian of IHL. Since then, the ICRC has facilitated the adoption of several IHL legal documents, such as the 1944 Convention for the Protection of Cultural Property. Building on this tradition, the official closing ceremony of this competition is usually used for the ICRC as an opportunity to raise awareness and provide a platform for discussion on current issues for IHL and Africa Union 2063 agenda for the Africa we want. It is this framework that a public lecture of the theme IHL and protection of cultural property was provided by the Institute of National Museum of Rwanda and UNESCO on cultural property protection in the event of armed conflict. The effect of armed conflicts are felt in a way far beyond the tragedies that we are unfortunately familiar with. Cultural property, like for example museums, arts, archaeological sites and monuments, are at the center of one people's identity. Attacks on cultural property are so much more than material destruction. It's an attack on identity, memory, dignity of an entire population, and even on humanity. I would like to take this opportunity to thank the government of Rwanda, the organizing steering committee, the 5 schools of law, the Rwanda Red Cross Society, the public and private institutions which send different judges, namely the National Public Prosecution Authority and the Rwanda Bar Association, to inspire the Mooters and support them in this competition. I would like to thank my ICRC colleagues as well for their support and to make this event a success. We would like also to thank the Justice Dr. Aimé Muyoboke Karimunda for his highly appreciated support, including his willingness to address us this morning as a guest of honor. I would like to take this opportunity to wish the winning team a success in the Africa Moot Court competition in Nairobi, and we count on you to make us proud, your country, your school, and the ICRC delegation in Rwanda. Thank you very much and good luck. And I would like to invite Justice Dr. Aimé Karimunda for the final speech.
Thank you very much for the invitation. I'm coming from the judiciary, but I was raised by the academia. So during the introduction of the teams, the master of ceremony announced that he would also give to the winners degrees. So the degrees were not yet awarded. So maybe they can be awarded before we officially close the ceremony.
Yeah, these are certificates for all participants. We are requesting Kaitesi Fib to come forward. Okay, Bozigi Derek. Umutoni Wase Rosette. Ngoga Samuel. Isimbi Denise. Muza Faraja Judith. Irahoza Gilen. Matinu Samuel Frank. Still, we have also some gifts for judges. We would like to start by the chair of the panel,
Madam President.
Prosecutor Charity Wibabara. Yeah, yeah. We may also request the senior in the panel. The senior in the panel. Umurungi Providence. We may also request Maitre Magiba Ingana to come forward. We also request Nyirirugo Jean-Marie to come forward. Then we may request the youngest in the panel to come forward, Ndahayo Eucharist. Thank you very much. Thank you very much.
Allow me to start by recognizing the bench, because I'm coming from the judiciary, honorable judges, honorable the ambassador representing the Minister of Foreign Affairs, Madam Providence Muringi representing the Minister of Justice, honorable the head of delegation of ICRC, Mr. the President of the Rwanda Bar Association, Madam Charity Wibabara, representing the Prosecutor General. I've seen that there are many of my former colleagues, lecturers, and dear participants, ladies and gentlemen, all protocols observed. It has been mentioned, I'm here on behalf of the Chief Justice, Dr. Faustin Heziryayo, who could not make it today. Dr. Faustin Heziryayo could not make it because of a busy schedule for on this Friday. Therefore, I have a great privilege to represent him in this closing ceremony. I wish first of all to congratulate all the participants. I think it has been repeated, and it was rightly repeated, that what matters is the participation rather than winning, because the process of moot court leaves lessons to everyone who was involved in it. But also I'd like to give congratulations, however, to the winning team. 5 universities have participated to this competition, organizing all students and the lecturers, establishing competition rules, harmonizing the agenda of judges coming from different institutions, were really themselves very demanding. But in addition to this, the event has been so successful despite the fact that all participants have to conduct COVID tests before, to observe social distances, and several times to be wearing masks. Organizing successful competition in the period of a world pandemic sends to the youth here present the message of resilience and proves that organizers' spirit remained focused on the light at the end of the tunnel despite a troubled time. Did the spirit that guided Professor Francis Lieber, who, although many voices had called for harsh punishments against American Confederate rebels that were the enemy by then, stated that for humanitarian reasons, even in times of rebellion, the customary rules should continue. This small sentence was soon adopted as an official viewpoint and led the average officer to consider that laws of war were not only rhetorical expressions that would justify his own conduct and damn the enemies. As you know, immediately after, Francis Lieber started drafting a comprehensive set of rules where American law of war was silent. President Abraham Lincoln quickly adopted rules under the title of Instructions for Government of Armies of the United States in the Field. Originally, the text was not binding, but General Henry Weger Halleck, in charge of the implementation, stated that they should be considered as the general principles addressing problems of guerrilla warfare, status of rebels, the applicability of law of war to internal armed conflict. The rules included penal sanctions for not observing laws and customs of war. By including penal sanctions, the Lieber Code of 1863 was far ahead of 1856 Paris Declaration, 1864 Geneva Convention, and 1868 St. Petersburg Declaration. None of these treaties contained penal sanctions simply because states did not discuss the issue of individual criminal liability during the negotiation. Ladies and gentlemen, looking back over the past through the wrong end of the telescope, one has the impression that although the methods of war have evolved, new weapons are resurging with the use of drones and remote-controlled guns. The consequences of war on humanity have, however, remained the same and dramatical. The circumstances for rebels, prisoners of war, civilians, cultural sites, infrastructures that are not military targets in the 19th century America might be similar to those in Alabasta, where in addition to prisoners of war, there were 120,000 civilians deliberately subjected to hunger and transformed into military target by one of the belligerents. Major General Dragon's decision to prohibit humanitarian aid, including food and medicine, in Verdansk, targeting survivors of famine and disease with military weapons, destroying oil fields, and indiscriminately bombing the city, brought you in the heart of a modern humanitarian law, but also at the intersection of this branch of law with human rights law, including the law of environment. We believe that the purpose of disseminating humanitarian law, especially among the youth, is for you to define the world in which you want to live in. Which Rwanda do you want? Which East Africa do you want? Which Africa do you want? In which kind of a planet do you want to live? Do you want to live in a world governed by law and reason, or do you want to live in the world governed by arbitrariness, where the powerful abuses the weak, the rich abuses the poor? A half century ago, jurists did not believe in the enforcement of international humanitarian law. In 1952, soon after the Second World War and the Nuremberg and the Tokyo trials that were the premises of individual criminal liability for violations of international law, the eminent jurist and the judge of International Court of Justice, Sir Heinrich Lauterpacht, stated that if international law is the vanishing point of law, the law of war is even more conspicuously the vanishing point of international law. For him, it is in particular with regard to the law of war that the charge of mischievous propensity of unreality has been leveled against the science of international law. The very idea of the legal regulation of a condition of a mere force has appeared to many incongruous to the point of absurdity. Sir Hersch Luterpart made the statement likely because the premises of the Genocide Convention to establish a permanent international court failed to materialize in his lifetime. However, today, we know that international humanitarian law is no longer a toothless lion. Domestic courts, ad hoc, special, and permanent international criminal courts have proved for the last 2 decades that individuals, regardless of their status, should be accountable for breaches of international humanitarian law. Therefore, although the case you have argued before this honorable court is moot, the law that you were analyzing and interpreting is real. The facts in the most case might also be similar to those in Tigray in Ethiopia or Cabo Delgado, Mozambique today. Some of the judges here present were students practicing moot pleadings yesterday, but today they are dealing with real cases of a similar magnitude. This means that all these efforts and investment, they are not for drama. They are part of ICRC's commitment to build better leaders for better future for all of us. The position of your judges and the lecturers will be yours tomorrow, and for you tomorrow is today. Our responsibility is to give you the maximum exposure with the hope that your spirit will remain constantly armed with the willingness to play your role in bettering the world and seeing the light at the end of the tunnel in troubled times. As Frederick of Martens would put it, we have always to abide by the laws of humanity and the requirements of the public conscience. Well, ladies and gentlemen, in the way of a conclusion, and on behalf of the Chief Justice, I would like to commit that the judiciary of Rwanda is willing to work with all the stakeholders, including the RCRC and as well as universities, to play its role in skills and the knowledge transfer in programs such as this one. Please note that the Honorable Chief Justice would welcome any project that would lead to the development of the law and the rule of law. So I think all these I've said. Thank you. Thank you.